Good afternoon, Madam Registrar, Deputy Registrar. I believe everybody's on.
Yes, Judge.
Thank you, Madam Deputy Registrar. Please open the proceedings today.
Thank you, Judge. Good afternoon. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Barbados. Hearing of application in CCJ application BBACR number 1 of 2025 between Danny Lamar Husbands and the Commissioner of Police. The members of this afternoon's panel are Madam Justice Raj Nosley, presiding judge.
Good afternoon, everyone.
Mr. Justice Jamada.
Good afternoon to everyone.
And Madam Justice Ononewu.
Good afternoon, everyone.
May we have the appearances, please? Thank you.
If it pleases this honourable court, I am Andrew Pilgrim, and with me is my learned friend, Mr. Marty Garnes, and we appear for the applicant, Danny Lamar Husbands.
Thank you, Mr. Pilgrim. For the respondent.
Good afternoon, Your Honors. My name is Crystal Delaney, and I appear on behalf of the respondent, and with me is Mr. Kevin Ford.
Good afternoon again, and thank you, Ms. Delaney. Ladies and gentlemen, we are here for an application for special leave and an application that this matter be heard urgently, and also raised was the issue of bail. Mr. Pilgrim, I believe we've received the affidavit of opposition from the respondent, from the DPP's chambers, as well as speaking notes from the DPP. And we have seen your speaking notes as well. So, Mr. Pilgrim, you want to address us for some time on whether and why we should grant special leave in this case, and what you say about bail. We'd be interested in those matters, unless there is something else that counsel wishes to raise.
If it pleases this court, we can go straight to that. This matter comes before this honorable court in the context that the matter was drawn to my attention because, quite frankly, no one is going to prison for this type of quantity anymore in Barbados. Before
you get there, Mr. Pilgrim, there was a matter that we wanted clarification on. The magistrate had convicted and sentenced. What was the date of that? If you could give us that, please, so that we have it for the record. See if you can. I'm going to ask my learned friends on the other side as well if they can confirm, because the document we had with the reasons doesn't show the date. Okay, and what we want to find out is what happened to your client after that. He was present at court physically, and I think that would have been a week ago, Friday. No, not before the Court of Appeal judges. We're talking about the magistrate. What happened after? He was liberated on bail, I think, a few days after. Maybe 2 or 3. So he's not really served any part of the sentence other than 2 or 3 days then, and the week between the Court of Appeal decision and today's date. And he received bail from whom? From the magistrate. From the magistrate. We have a section in our Magistrates Court Act that has always been interpreted in the mandatory form to say that when you appeal, essentially once you have 2 persons to sign a recognizance in the sum of $500, I think it is, that you shall be liberated. That's been changed to may, but in practice, the magistrates generally will liberate you more or less forthwith once the appeal comes to their attention. I think my friends will confirm that.
So, Mr. Pilgrim, he was put on 2 bails, security $500, and two sureties. What was it?
From my records, I'm only seeing 1 surety, his girlfriend.
But 500 with 1 surety?
I think that is correct, my lad. As I said, we don't have a lot of the documents we would usually want to have from the court below, but our understanding is that she signed in the sum of $500.
And you were going on to tell us about the Court of Appeal. After the Court of Appeal's decision, I think it's last Friday, is it, or last Wednesday?
Just confirm for me.
March 6th.
March 6th so that's last week, Wednesday, I think.
Yeah.
So that
And you were about to tell us what happened after that.
On the day before court, there was a purported arrest, a botched arrest of him before the hearing. Then he was told to come to court on his hearing date, which he did. And then after the appeal, he was remanded in custody and sent to the prison.
Yes. And then
is there pending this? Yes.
Yes, okay. Anything else from my colleagues you want? Because we did want some clarification on that.
Well, we're still waiting on the magistrate date of conviction and sentence, right? I don't know if the DPP can. Ms. Delaney, can you give us that information so our record is complete as we go along?
I'm reaching out to the criminal records office as we speak. Our paperwork does not have the date as well, but I'm reaching out to the criminal records department. So as soon as I get that information, I'll let the court know.
Thank you, ma'am. Yes. So, Mr. Pilgrim, you were about to embark on your submissions.
Obligement.
Yes, thank you.
Essentially, it's very difficult for me not to say this in very basic terms. It seems to me that our courts at the Supreme Court level and at the Magistrates Court level are sentencing people with large quantities. When I say large, I mean above 20 kilograms. Both magistrates and the Supreme Court, sometimes as high as 50 kilograms to fines. And this is happening across the board, almost without exception. And certainly, there is no person that I have been able to identify, because as the court will appreciate, we do not have court reports of the Magistrates Court hearings. But I can find no person who has been sentenced to incarceration for a quantity under 100 grams. And I invite the state to
Did you just say up to 50 kilograms with fines?
Up to 50 kilograms are getting fines.
In both the magistrates and the High Court?
In both the magistrates and the High Court. Persons with more than that as well. And I invite my friends, if in the event that we have a full hearing, which I hope we do, we will be able to give a lot more detail on those sentences and the type of quantities.
I'm assuming that Mr. Pilgrim, the DPP will have that information at least.
Absolutely.
Because that information is processed through the DPP's office. All those prosecutions will be processed through the DPP's office. The magistrates' court's proceedings also go through the DPP's office?
No, Your Honor. Only the DPP would only have conduct of the matters in the Supreme Court. We're still police prosecutors in our magistrates court across the board.
Okay, good.
But the challenge, the specific challenge here, in my view, or what was most abhorrent to me, was that we have two courts that really deal with our airports. One being the court of the Honorable Magistrate in this matter, and another one, it's a split jurisdiction, District B, one sitting up at Oistins near to the airport, which is this court, and another one sitting in St. Joseph now for logistical reasons. Both of these courts receive people from the airport who traffic in relatively large quantities, not grams, kilograms, 20 kilograms, 15 kilograms, 18 kilograms, 13. And I may have done 100 in the last year, because the first time that Barbados finds itself having drugs coming from the north to the south, so that we get large quantities of drugs coming from Canada, especially into Barbados. And this magistrate and the other magistrate at District B and others who sit itinerantly for that jurisdiction are routinely finding these people, many of whom are students and older people who may be preyed upon by some large enterprise, I don't know. These people, none of them are getting incarcerated. All of them are getting fined.
So, Mr. Pilgrim, let's cut to the chase. Your position is that we hear the DPP obviously on this, but as far as you are concerned, this is a case of 60 grams, and ordinarily 60 grams, right?
60, I think it's 90, Your Honor.
90. Okay, 90. No. I'm happy to be corrected. Forgive me. I'm not always good enough with the facts. Sorry. This is a case of 90 grams, but for the magistrate's reasoning of previous convictions, this particular magistrate, you are saying in this particular court, would ordinarily have imposed a fine, but you say with some measure of conviction, based on the historical record, would not have imposed a custodial sentence.
I do, Your Honor. And I also say that several people, just so that I'm clear on the question of the record as well, persons with convictions before this magistrate and others with this quantity are all getting fines. There is a person, as I said,
Mr. Pilgrim, saying it 5 times is not, once we have the submission, your submission is that before this magistrate in this court in Barbados, persons with this 90-gram thing would not have been incarcerated, and that the only reason that this person, Husbands, was incarcerated was because the magistrate took into consideration 2 prior drug-related convictions, applied a principle of escalation, and therefore imposed a custodial sentence. And you say there's an error in law in that. Is that right?
Yes, Your Honor. I was just making
what is the error?
Yes. No, before you go on, I don't want you to leave that point, Mr. Pilgrim. You mentioned that some of the persons who were trafficking and who were found guilty by this very magistrate, some of them were students, some were people who were preyed on, and so on. Are you in a position to let us know, because you say you were there for some of these cases, or many of them, was there a reason given by the magistrate as to why a fine was imposed and not a custodial sentence?
Your Honor, my reading and understanding of the reasons by that magistrate and the others is that this is not these matters, trafficking in marijuana, in quantities less than, shall we say, 100, I beg your pardon, 100 kilos, no, 100 pounds, I think is the standard they're using. That persons trafficking in those types of quantities do not cross the custodial threshold referred to in Section 35 of the Penal System Reform Act. And the ones above 100 are committed to the Supreme Court, the matters being hybrid.
That 100 is kilograms or pounds? You said
it's pounds. It's pounds. It's not, I beg your pardon, Your Honor. It's pounds, and it is not found in the law anywhere. It is an arbitrary standard that the magistrates and the DPP seem to have agreed. I'm not saying that in an insulting way. It just seems to be what they're applying to determine what hybrid matters go up versus coming down.
Yeah, you're a bit spotty from my end because we are online, Mr. Pilgrim. I want to make sure I heard you right. You said this seems to be something that the DPP has agreed with the police. I didn't follow it. I'm sorry.
Your Honor, I am instructed that between the offices of the DPP, the Commissioner of Police, and the Office of the Magistrates, they have a cutoff point for determining what goes to the Supreme Court on hybrid drug matters, and that cutoff point is 100 pounds. There was a time that they relied on a street value, but they no longer do that. They apply the 100-pound rule, as I understand. I have asked for written communication of that in the past, but I don't have that. And there's no law that speaks to it. But I think the general practice is that if you're 100 pounds or more, you go up.
So, Mr. Pilgrim, if I'm following you correctly, based on this practice that you're saying has developed, the court would not essentially, based on the terms of Section 35(2), consider the offense to be so serious that only a custodial sentence could be justified for the offense.
That is correct, ma'am.
Yes. So, Mr. Pilgrim, unless I've missed it, I didn't see much of what you told us in any of your written documents. Perhaps I missed it.
Your Honor, I hope that it is housed in what I think we are calling 3, 4, and 5.
No, I mean the detail that you just gave us of the practice.
No, Your Honor, am of the view that much of what I'm saying sounds closer to evidence than to submission. And I'm hoping that the state will bear me out in those positions. But I was not in a position to put in affidavit these matters before the court. But honestly, I do not think that anyone can dispute that these types of quantities are being dealt with in the way that I say, and that this person is out on a limb. The only other point that I was, when I was addressing the court earlier.
No, before you move from there, though, was this a matter at all raised or mentioned in the Court of Appeal in the interest of transparency and fairness, that this is a practice between the Office of the Magistrate, the DPP, and the Commissioner of Police, and the £100?
I don't know that the £100 argument was made.
Practice.
I don't know that argument was made, but might understand that the argument was, however, made that persons with this quantity and far more, or much, much, much more, are routinely being fined. That was the thrust. In fact, I suppose one might criticize the arguments below by saying that the basic thrust was no one with this quantity is going to prison, and people with 20 kilograms and 30 kilograms, 15 kilograms are all getting fines. And that was the basic thrust of what was submitted below. And it was perhaps not buttressed by whether the court was applying the principles under the Penal Reform Act so much.
Yes. Could I ask one other question? I know you want to go on, and I know my colleagues may have some other questions, and it is a Friday afternoon after all. But I do want to ask this. Is there any mention at all in the Court of Appeal's judgment, just in case I missed it, as to anything near to this point?
No, they don't address that at all, unless I missed something.
Yes, thanks a lot. You may proceed unless my colleagues have something else.
Your Honor, I think that the thrust, and as I understand it, of both the court below and my colleagues from their speaking note, is that Walter Prescott, which was, I think was 2006 decision, spoke very heavily and seriously about drugs being a scourge and how terrible it was, and so on and so forth. And that it is clear that the court has the power to have fines up to $1 million and to lock up people in the Magistrate's Court for up to 7 years. We don't dispute any of that at all. We don't dispute any of that in any way. What we are saying is that this person is being treated in a significantly different way. And the point I was trying to make earlier, not trying just to repeat myself, but to say that this is also being done with Barbadians who have previous convictions. This quantity is just not taken that seriously anymore. So that in my research, again, these are just notes from the records of the court, which if we get a full hearing, we can present them. A person with 57 convictions for marijuana was still fined with a larger quantity than this one, because this quantity is just not taken that seriously.
All right, so Mr. Pilgrim, let's try and anchor this, because to get leave, you have to satisfy certain grounds.
Yes, sir.
A, that there has been an error of law that could lead to a miscarriage of justice, that there is a precedent that is on the record that can be that is uncertain, or that can undermine the certainty of delivery of justice, and so on. And of course, the case must be arguable. So if we look at the two relevant statutes, focusing on section 35 to 37 of one, and then section 40 of the other, can you just very succinctly frame why you say you should be granted leave that is crosses the threshold of arguability in terms of what you need to establish before us grounds for getting leave? Because ultimately, that's the forensic exercise we are going to apply. Everything you've said is wonderful to listen to. Until you can condescend to that kind of argumentation, then basically we can't help you. Correct.
Your Honor, my interpretation of the Penal System Reform Act and its tone between 35 and 42 of those sections is that they are inviting our courts always to weigh up and make a decision
about the threshold and the crossing of the threshold for incarceration and making a determination as to when a person has crossed that threshold. The general thrust of the Act is that it is looking towards the most violent and serious sexual offences to be the bulk clearly of those. In this case, I beg your pardon.
Paul, would you say that is the policy of that scheme of legislation?
I would say so, Your Honor. So that this legislation arose out of a context in which the government made it clear they had a mandate not to be incarcerating as many people as they were, to put it simply. And they formed a board, and this act, the thrust of this act was to find alternative sentences and to ensure that incarceration was reserved for only the most serious.
Is that anywhere in the Hansard by the proposer of this legislation, the way you articulate that?
I do believe it is, Your Honor. I sat on the board.
If we grant leave, and I'm not saying that we will, if we do, that is certainly something that I would be interested in having a look at. Yeah, let's go along. So that's the policy of the Act. The Act seems to say that certain criteria must exist to deem a conviction serious enough to qualify for incarceration. Agreed?
Yes, sir.
Is it your? I'm just trying to move us forward if we can.
I'm obliged to you, Your Honor.
Yeah. Is it your position that the considerations of the magistrate do not fall within the statutory criteria for deeming a conviction serious enough to justify a custodial sentence?
Yes, Your Honor.
Further, there is in section 35, 637, I think it's 1 and 4, a requirement that a written report as to a pre-sentencing report be obtained, and if it's not done at a first-tier court, the Court of Appeal shall do it and be considered. Is it also your position that the failure to do that before deciding to impose a custodial sentence is an error of law, which, if it stands, leads to either same criteria, potential miscarriage of justice and/or precedent which is uncertain or wrong, maybe?
Yes, Your Honor. Yes, I don't think I need to go further, but I have noticed that the Court of Appeal sometimes do and sometimes don't, but generally that they do when incarceration is on the table. So that even if they were of the view that it could be interpreted, could be made, it seems to me that in most of their hearings, where incarceration is on the table, they ensure that they get a pre-sentence report so that they know that the sentencing is properly individualized and appropriate for the person before them. So
right.
Yes.
And simple question of fact is, was that done? I mean, I think I'm asking an answer because from the record, we've also read it, but I need to put it on this record. Was that done by either the magistrate or the Court of Appeal, i.e. sought and or obtained a written pre-sentencing report?
It was not done, sir.
It was not done. Yeah. I'm sorry I interrupted what you were going to say. I just like to have things very clear from my point of view. Those are the things that interest me, and so yeah. So please, if you have other things to say, don't let. I hope I have not deterred you.
Yes, as we move on, Mr. Pilgrim, I wanted to ask you something about Prescott, because I think you pointed out it's a 2001 case. How do you see the words in Prescott, which are in the Court of Appeal's judgment, as to the obvious and plain intention of Parliament in what I would say trafficking cases and so on? How do you see that lining up with what you told us about the policy behind this legislation not to incarcerate? How do you see the two of them gelling together?
Your Honor, one is dated, that Walter Prescott decision is dated, and I regard it as being out of sync with what is happening in the country now and out of sync with the Penal System Reform Act.
Has the drug trafficking laws been changed to reflect this new thinking that you have impressed upon us today?
Your Honor, no, not at all. And there have been amendments to the Act, but they relate to things like allowing marijuana now to become a sacrament and allowing persons to have up to 14 grams and receiving what is being called a citation for that. So that and there have been various speeches and so on about, but they have no meaning. The throne speech from the president indicated that essentially that legalization is coming. So one may have formed the view that the future of these matters is that they may be going a completely different direction. So the policy and the law imply that a change is coming, but the powers under the Act to incarcerate for up to life imprisonment and for millions of dollars, they remain on the books.
When were Section 35 to 37 or 40 or whatever it is, when were those introduced relative to the Prescott case?
My recollection is that they predate the Prescott case.
Right, okay.
The only other point in terms of that I think is useful, Your Honor, is that the Court of Appeal in the case of Gooding, I think it is, which I hope is before this Honorable Court, at page 59 of 59, at paragraph 12, this would be a judgment of the same Court of Appeal, similarly constituted, led by Sir David Simmons, is saying
But the year of that one, just remind me, please, Mr. Prescott, Mr. Pilgrim. The Gooding case is what year?
Just give me the year. I feel like it's 2006. We're just checking that.
Sure, thank you.
Two thousand six. 2006.
Thank you.
This is after the Prescott case.
That's my understanding, yes, sir.
Yeah.
And Chief Justice Simmons at paragraph 12 is saying, we've examined a number of drug cases in the district jurisdiction between 2004 and 2005, which is this same jurisdiction, because it's the airport courts. And penalties imposed on Gooding are not out of line with those usually imposed by that court, which is a fine for a much larger quantity involved in the Gooding case. We've observed the sentencing policy that courts of that court to impose heavy fines or in default of payment to sentence a term of imprisonment. This is in the context of them discussing whether people should be fined and confined. But I think that the courts were already accepting quite soon after Prescott that the general trend was that people would be getting fines for the magistrates' courts marijuana matters.
Anything else, Mr. Pilgrim, from your side?
We want to hear him on bail, Chair.
Yes,
if we reach
certainly. If we
so
get
that at least the DPP can respond in once.
Yes.
If you are successful on the question of bail,
Question of leave.
there are two questions. First, sorry, Judge Ono, you wanted to ask something?
No. I was just saying, I think you meant on the question of leave. If successful on the question of leave?
If successful on the question of leave, then there are two things about bail that we want to hear you on and the DPP. One is, can bail be granted on this special leave application, or does it have to await your filing of, if special leave is granted, of an appeal? And then as a question of law, obviously, and then two, supposing that on special leave we can bail, well, what is your submission on that?
Well, Your Honor, it's my submission that this court is empowered to grant the bail by way of staying the order of the court below, or by specifically granting bail as pleaded in our application. The challenge, obviously, with this sentence is that it is still comparatively short, and it's our view that the applicant would lose all his rights if he's not admitted to bail pending resolution of the matter.
in as much as he's 5 days into his 7 days.
Yeah, okay, fair enough. But that's okay. But what were the other considerations for bail? Flee risk, likely repetition, danger to society. I mean, this is a bail application, right? So surely you have to at least cover those grounds and not just talk about.
Yeah, and conditions.
Yeah.
Your Honor, in looking at the circumstances of the applicant, it would be our humble submission that he is not a flight risk, that all of his ties are to Barbados. He is a Barbadian with all of his attachments, his family and so on in Barbados. There's no likelihood of him interfering with the investigation in any sense, in as much as the investigation phase is entirely beyond him now. And there is no reason to believe that he would flee. Indeed, when this matter came on for him before the Court of Appeal, he attended and walked into the court of his own accord and cooperated entirely with the process and remained in Barbados throughout the period after bail was granted in the Magistrate's Court as well, and has never in any way flouted the terms of his bail. And I've seen none of the terms of our Bail Act that he is likely to run afoul of.
And you mentioned, Mr. Pilgrim, about staying the order of the Court of Appeal. That is by way of a second option after the bail?
Yes, Your Honor.
And would conditions be attached to that as well? That might be more conveniently put in a bail document?
Yes, Your Honor, except for the fact that I don't think we would need to change the terms of the bail that he was on before, because he was compliant and the record reflects that he was compliant throughout.
So what you suggest, that he put on $500 on his own bond? He was his own surety?
No, his girlfriend had signed on his behalf. So
you're saying that you should put on bail, fixing the sum of $500, secured by a single surety?
Yes, Your Honor. I was hoping that perhaps it could be termed that the original bail that was signed at the Magistrate's Court, be allowed to continue pending resolution of this matter. So that if I'm wrong about the $500 or about...
But won't that have lapsed?
Not if,
is that bail indefinite? That bail can't be indefinite, because otherwise he'd be out on bail now.
No, Milad, Your Honor, I was thinking in terms of if this court ordered a stay of those proceedings, I was perhaps erroneously of the view that that bail could be allowed to continue pending the resolution of the matter.
Mm-hmm. Anyway, but the DPP may be able to have other...
Yeah.
I doubt whether the DPP will be contesting, if bail is granted, the terms like one surety with reporting to a police station or whatever they would find appropriate. And we wouldn't object to any terms that are reasonable to secure his appearance.
Thank you. Anything else, Mr. Pilgrim?
No, Your Honor. I think those are the points I wanted to make essentially, though not necessarily in the order I hope to make them. And I'm obliged to the court for the assistance throughout. I have to admit to being somewhat frazzled. I feel like I've been in 6 courts for the morning, one of which was our Court of Appeal, which has handed down a new decision which says that magistrates are entitled to take into account the fact that persons have other matters pending when sentencing. So I'm really in a state of utter confusion.
All right, let's not confuse this hearing with that. You may have another opportunity, but so thank you.
Thank you, Mr. Pilgrim, and if you didn't tell us, we wouldn't know. So as a good friend said to me, don't ever say.
Obliged, Your Honor.
Thank you. Ms. Delaney?
Yes, Your Honor.
Thank you, ma'am.
Your Honors, the applicant was convicted and sentenced on the 7th of August 2024.
Convicted and sentenced?
Yes.
Thank you. Mm-hmm. And you have any instructions after that for bail? when
If
bail
leave
is
is
granted?
granted, Your Honors, I have no objection. No, I don't have any instructions on the bail amount or anything like that. But I can say, Your Honors, if leave is granted, I have no objection to him being granted bail.
Okay, thank you very much.
What about terms?
Probably bail in the sum of. I have to think about that, Your Honor.
All right.
Yeah. So by the time you are through with your submissions, you might have some instructions to give us on that aspect.
Yes, Your Honor.
Yes, okay. So your junior or Mr. Ford, is it, can do some thinking for you at that time. What do you tell us about the application for special leave? Because we've seen your affidavit in opposition, and we've also seen your speaking notes. Yes, Mr. Lanish.
Lydia, as I understand it. What? Sorry?
No, I was about to say, and you've heard the interaction between the court and Mr. Pilgrim this afternoon.
In response, Your Honor, to a question asked by Mr. Justice Jamadar, my learned friend stated that his contention with the sentence imposed on the applicant is that but for his previous convictions, he would have been given a fine. My first submission in relation to that, Your Honor, and in relation to grounds 1 and 2 of the no application for special leave to appeal, is that the court was entitled to consider the previous convictions of the applicant in determining what was the sentence, what kind of sentence, and the nature of the sentence, the length of sentence to be imposed on him. This court in Elliston Graves considered Section 40, which my learned friend relies on, of the Penal System Reform Act. And in this discussion of that section, the court stated that if the convictions were similar, and in essence, if they were not old, and the court was entitled to consider the previous convictions in determining as an aggravating factor of the offender. So based on that, Your Honors, is my submission that the court was not bound to apply Harewood. The case
Mr.
of
Laney,
Harewood.
just a quick question. In Graves, as you just pointed out, the previous convictions, as you just submitted, were used to assess personal aggravating factors related to the offender. But what I wanted to know is, would previous convictions, based on your understanding of the Act, could previous convictions be taken into account for the purpose of determining whether the offense was so serious that only a custodial sentence can be justified? There's a difference, is there not?
Yes, there is. Strictly speaking, Your Honor, I would say no, but to the extent that, firstly, unfortunately, the magistrate's reasons do not expressly state what she considered for the offense and the offender and what was the starting point and how it was elevated. We have a lump sum of circumstances which she considers, and she says she considers the aggravating and mitigating factors of the offense and the offender, including his previous convictions. I would say, though, Your Honor,
Mr. Laney, let's turn I don't want to cut your flow, but I just want to address the point you just made. If we turn to the magistrate's reasons.
Yes.
Would you say, when you look at the last paragraph, that the previous convictions were not taken into account for the purposes of determining whether a custodial sentence can be justified?
Yes, they were.
So, sorry, did you understand the question,
They were
Mr. Laney?
considered.
They were considered or were not?
The magistrate did consider his previous convictions in determining the the nature of the sentence to be imposed.
In other words,
Mhm.
that was
In
the
determining
trigger
whether
to
this, in determining
sorry.
whether the offense was so serious that only a custodial sentence could be justified.
Yes.
Okay.
In,
And
in response, go ahead, sorry.
no, please proceed.
No, what I wanted to follow up then, Ms. Delaney, was this then an error on the part of the magistrate? Having regard to Section 40.
I would say, Your Honor, that the magistrate was entitled to consider the previous convictions in determining whether or not they were personal aggravating factors.
I think we are all agreed on that, and that's what Graves says, so we're grateful for that. But I think the more interesting question, at least for me, is whether there was, when you look at the reasons of the magistrate, and in particular, where she grounds and justifies the custodial sentence, she says this is because of X. And what I'm asking is was she wrong in law in doing that?
I would say, Your Honors, that the magistrate in considering that custodial sentence was appropriate given his previous convictions spoke about specific deterrence. And in this case, she determined that given the need for specific deterrence, that a custodial sentence was warranted. So to that extent, Your Honors, is my submission that she was not incorrect in considering his previous convictions, in deciding what type of offense was best fit for this case and whether the custodial threshold had been crossed for this appellant.
But Ms. Delaney, we have heard that, but I think your answer, the judge was no in relation to the question whether the previous conditions be taken into account to determine whether the sentence was so serious. And so my understanding from the record is that you agree that the magistrate did take into account previous convictions to consider whether the sentence was sufficiently serious to justify a custodial sentence. That's what you said to us. Yes?
Yes.
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 On a leave application, the test is it arguable that that could have been an error of law? Is it arguable that that could have been an error in law, contrary to the statutory regime? That's the test, right? If it's the test for special leave is it must be arguable.
Yes.
You accept that the magistrate didn't follow what the statute said. So is that not an arguable position?
Sorry, I didn't accept what the magistrate did was contrary to the act. To what extent? No, I'm asking you a question, sorry, but I think I'm not understanding. Sorry.
Oh, yeah, but you see that's what I think. I don't think maybe I'll pass it back to because Judge you raised it. Do you want to pick it up?
No, Ms. Delaney, what I was interrogating with you was whether there was an error of law committed by the magistrate with respect to the application or non-application of Section 40, Paragraph 1 of the Penal System Reform Act. More specifically, whether in determining whether the offense in question was so serious that only a custodial sentence could be justified, whether the judge erred as a matter of law in taking into account the previous convictions of the offender. So that's why I asked if, when we look at the magistrate's reasons, if what we see is a consideration of the previous convictions of the offender in determining whether only a custodial sentence could be justified. And if so, whether that would be an error of law.
Or can I just reframe that, Judge? That could be an arguable error of law because our standard is arguability.
An arguable error of law.
You don't have to concede that it is,
sure.
But is it arguable?
Is it arguable that that would be an error of law? Thank you.
Yes, I will not concede that it was an error, but I would concede, Your Honors, that it isn't arguable. That it is arguable.
Thank you, Mr.
Thank you, Mr.
Lee.
Lee.
Yes, thank you very much. Please proceed if you have other things. Or as said, we've seen your speaking notes. But anything else that you wish to say to us, please go ahead.
Given the concession, Your Honors, I'm not sure if unless the court wishes to hear me on anything else in particular.
Well, the only other arguability point that we raised with Mr. Pilgrim that I think in fairness we should raise with you is the pre-sentencing, the failure to request both by the magistrate and alternatively by the Court of Appeal to request and consider a written pre-sentencing report before choosing to impose a custodial sentence. I think that's 37, it may be 37 of the I've forgotten the act now, but of the other act. Sorry.
The Penal System Reform Act.
Thank you very much. Yes.
Yes, Your Honor. Yes, Your Honor. Sorry. The act does provide that if no pre-sentencing report was ordered in the magistrates in the court below, then the Court of Appeal should have ordered the pre-sentencing report. If it was going to uphold the custodial sentence.
Right. And that was not done, we are told on the record, right? Agreed? You agree that was not done, either by the magistrate or the court?
I agree that was not done.
So would you say that is also an arguable error of law? I.e., that the court, yeah, okay, good. The only last thing that I certainly want to ask you about is Mr. Pilgrim gave us quite a long chat about what happens in these two courts and this £100 rule. He says to us that he is certain that you would accept that as an accurate statement of what happens in those courts, albeit he does not dispute what the law says. So I am not on whether the law says you could imprison for 7 years or fine for $1 million. What he said to us is, when you look at these courts, and you look at what has been going on day in, day out, for anything less, he says, than 100 pounds of marijuana, he knows of no custodial sentence imposed, and he knows that routinely fines are imposed. He says that that is a matter of common knowledge and practice. Do you have a position that you wish to express to us now on that or not?
I actually am not in a position to say whether or not that is common practice in the magistrate's court. But what I can say in relation to the £100 rule that my learned friend referred to earlier is I know that speaks to the committal threshold, a rough committal threshold. So if, generally speaking, someone is in possession of drugs in excess of £100, the matter will be committed. As far as I know, I don't know that that speaks to any sentence that would be imposed by the court.
Right.
It speaks to the committal.
That determines whether you do it summarily or you'll recommend indictable. That's your threshold for whether you recommend summary or not.
Yes, Milan.
Okay, good. It's all right. But you're not able to say that, so that the better way to frame it would be, therefore, in summary proceedings, and maybe Mr. Pilgrim, I'm just saying this because if we go forward, let's have some sort of coherence about how we frame what we're going to say. If the £100, if it is accepted that the £100 rule is a rough and ready rule for a choice, it's not absolute, a choice between recommended summary or committal, then I think the pertinent question becomes whether in summary proceedings, i.e. below the £100 rule, whether in summary proceedings, it is customary for fines. And you don't have to articulate a position on that if you are not advised, if you don't have the information. Chair, I have nothing else to ask. I am fine.
Thank you, thank you, Judge. Mr. Laney, if it is that we are minded to grant special leave, thank you for letting us know that you in that position, what your position with bail would be. That is much appreciated. But what I wanted to ask is,
As to the grounds of the notice of application, what would be, in your view, the grounds that have been raised by both by way of the documents and today by your friend? Would it be grounds 1, which concern the previous convictions in Harewood? Ground 2 concerns the custodial sentence. Ground 3, which says it's excessive and contrary to sentencing custom. I take it that would be Gooden. I see Gooden here, and that would be where this practice of the £100 would fall. And then ground 4, again, the seriousness of the offense and the custodial sentence. Would those be the 4 grounds?
I'm thinking, milady, that an additional ground was actually raised today in relation to the procedure with the pre-sentencing report.
Yes, yes. Very well. And you would have no objection, Ms. Delaney, to the court considering that?
No, Your Honor.
Thank you very much.
And would you have any objection to both of you, I suppose, agreeing if we move forward on the Hansard in relation to this policy of incarceration in the legislation, so we get the benefit of what the Parliament of Barbados intended when it passed, the section 40 A and B, and
yes,
what was intended. Well, what's your position on that? I asked Mr. Pilgrim. He suggested that he would have no objection to, if we were to grant leave, bringing that information forward. Would you also support that? And I'm not speaking necessarily about a pepper and heart kind of strict thing, but giving us the information that helps us understand and not overreach into legislative policy. You know what I mean? We want to be careful, right? If we reach there. Yeah.
I have no objection to that, Your Honor.
Mm-hmm.
And I suppose, Ms. Delaney, you and Mr. Pilgrim could get together as well, if we move on, to supply those cases where the sentences have been, as Mr. Pilgrim indicated, or at least what are these sentences that are normally granted. Not necessarily that there were no custodial sentences, but we would like to know what would be and the circumstances, because that would be important. I can understand a student, somebody who's been taken advantage of, somebody who's come a single woman somewhere, so that we could actually see the distinctions between the various cases. But I'm sure you and Mr. Pilgrim have a lot of experience in that field. You can put that together for us. Anything else, colleagues, before we
maybe only to say, if they do that, will they agree maybe for a time period? The magistrate conviction was in August 2024, so it doesn't have to be excessively long. I suppose it has to be relatively contemporaneous, and maybe after we meet, and depending on what we decide, Mr. Pilgrim and Mr. Delaney can chat and say, if they choose to grant, if the court chooses to grant leave, we will be happy to do this for 2-3 years or whatever, so that it's not just a kind of open-ended thing going back to independence kind of thing.
Yeah. Mr. Delaney, what about bail? You said you would think about it.
Sorry, before I answer that question, I just wanted to say, in relation to the magistrate's court, is not computerized. So I don't know how easy it will be for us to get all of the information from the magistrates in relation to trafficking offenses. So
I guess I don't know. Yes. No, I take your point. And then Mr. Pilgrim, I guess this is where you would have to come in, because you may very well have that information in your office as to those matters that you have done. But we will have, where there's a will, there's a way, and we will find a way to get the required information. It may not be perfect, and it may not be all all the sentences, but at least we can try our best to get a good sample. I think that's the best I can do. I think that's what we did in either Pompey or Ramcharan. We got a fairly good sample. It may not have been all the cases done, on sexual offences in Guyana over that period. Anything else, Ms. Delaney?
Yes, milady. Yes, Your Honor, sorry. In relation to the grounds going forward, when the court asked me earlier, I was wondering if grounds 1 and 2 should be consolidated so that we just, well, pretty much that ground 2 be argued if it comes to that. And ground 3.
What do you say about ground 4? You think those could be consolidated too, 3 and 4?
Yeah. Yes, Your Honor.
Mm-hmm. Yeah.
And then the penal, and then the pre-sentencing report will be a third ground, so there will be 3 grounds instead of 6.
Mm-hmm. Yes. Mr. Pilgrim, how will that how does that sound?
I'm listening to my friend. I'm not sure that one can be so much combined with anything else. Unless my friend is saying, well, that's a point that she concedes up front. I didn't think that one could necessarily be mixed in with 2 per se.
Mm-hmm. Mm-hmm.
But I think 3 and 4 can go together.
Okay.
And if we go forward, we'll want to include the pre-sentencing point, right?
Yes.
Because there is some CCJ jurisprudence in Pompey and Ramcharan and so on, which is outside the statute, but it is creating a certain, it's part of the jurisprudence, albeit outside of this terms of the statute.
Yeah. Thank you, Mr. Pilgrim. Mr. Delaney, I still didn't hear you on what you said about bail. You said you would think about
I was thinking, milady.
Go ahead, please.
I was thinking, milady, bail in the sum of $2,000.
Any
With
conditions you propose?
With a surety?
One surety.
One surety.
Report to the police station once per week.
Which police station?
Mr. Pilgrim can assist us with that. You have to unmute, Mr. Pilgrim.
Yes, you're muted. I'm sorry, we're not hearing you. Mm-hmm.
Central Police Station in Bridgetown.
Central Police Station.
And instead of being so vague, once a week, can we be more specific so that it's not just any day a week, today, Monday, tomorrow, Thursday, you know what I mean?
Yes.
Every Monday?
Monday, yeah.
Every Monday?
Before 10 a.m.?
Maybe say midday, so
before
allow.
12 noon?
Yeah.
I don't know why the traffic is coming into Bridgetown, but if it's anything like Port of Spain, before 12 noon. Yeah, okay. All right, so we'll take a short break. We'll be back so that we'll have something more concrete to let you know.
Your Honor, I just wondered whether I think I may not have been entirely clear, and I hope I was not misleading the court in any way. I was saying that the £100 was the cutoff in making a case indictable. And I was saying that 100, I know of no case with a person with 100 grams or less going to prison. So I don't want those 200s to get confused.
Okay. So you say that the 100 grams was the threshold. I think Mr. Lady agrees with you for the case to be indictable, 100 pounds.
Yes.
But you also said that you do not understand that if you had less than 100 pounds, that you would you'd be incarcerated. I thought that is what I heard.
There are what I said, there are many cases, both in the High Court and in the Magistrate's Court, with persons with 50 kilograms, 25 kilograms, 40 kilograms, 15, all kinds of numbers, way above this amount, did not get incarcerated as well.
Mm-hmm. Okay.
But you are more absolute in what you just said, I assume, that you know of no case whatsoever of 100 grams of marijuana or less going to prison.
Absolutely.
Get it? Okay. So that's sort of the threshold that you have refined. Yes. Fair enough.
Okay, so we'll take a break. We will ask our judicial counsel, Ms. Sargent, to take us to another place, and we will come back to you shortly, so that we will take our cameras off here as well as our mics. Thank you very much. We'll be back shortly.
Pleasure.
Pilgrim, thank you, Ms. Delaney and the council with you. We've met and we have come to a decision that we will grant special leave to the intended applicant. The grounds of that special leave will be as discussed today. We will keep grounds 1 and 2 of the notice of application separate, but we will combine and consolidate 3 and 4. And of course, we have that extra ground on the pre-sentencing report that we would have as a separate ground as well. So rather than I try to do the order and in exact terms, the order that we will finalize, and we will try to get it out today, council, so that it would be available, because I imagine, Mr. Pilgrim, we intend to grant bail, that he will not get bail, he will not be able to access bail if he doesn't have a written order. I imagine so. So we will try to do that. Yes. So we as well, Mr. Pilgrim, we are abridging time for the filing of the notice of appeal to Wednesday, the 19th of March. So that is this Wednesday coming. And by consent, we will grant the bail. Bail is fixed in the sum of Barbados, $2,000 with a surety. The applicant will report to the Central Police Station on or before 12 noon every Monday, and that will commence from this Monday, Monday the 17th. And this will be until the hearing and the determination of the appeal or until further order.
Your Honours, I'm obliged to you. The surety is now present at my office. In terms of logistics, in the past, I know this court has interviewed the surety in person. How would the court like us to proceed?
I really would think I'm not sure that we would want to be interviewing the surety here. Wouldn't that be a matter that you could see about, Mr. Pilgrim, in your normal course of dealings with the magistrate's court? I see no reason why.
Your Honour, the only challenge is that I am not going to find any magistrate's court sitting at this time in Barbados for sure, and certainly not the one at Oystins, which is now sharing a court with another.
So, Mr. Pilgrim, all right, let us try and approach it slightly differently. If Ms. Delaney, this is the same surety who stood security. Yes, Ms. Delaney has no objection on the record before us today to that person being the surety. Will that assist you?
If we agree that that person can sign for his...
And therefore we can put the name in the order. In other words, if we agree the surety, one surety being
X.
Miss XYZ, then it's in the order.
And that person was the surety, Mr. Pilgrim?
Yes, Your Honor. Yes, Your Honor.
But Ms. Delaney, what is your position? Do you have a position on this?
I don't object, Your Honor.
Okay.
To that same surety being the surety now.
Okay, excellent. Mr. Pilgrim, what's the name so we can put it in the order?
Just ask Mr. Garms to confirm that very quickly.
That way the order will speak directly.
Chantel Brathwaite, Your Honor.
Could you spell that for us, please?
SHONTELLE.
And Brathwaite?
BRATHWAITE.
Okay.
And we should get, I think, Chair, we should get at least an address. I think that would be a minimum requirement for identification of.
Thank you, Judge.
Dodson Land.
Give it to me again, please.
Dodson, DODSON, Land.
DODSON, Land.
Black Rock, St. Michael.
Black Rock, St. Michael.
I'm just curious, Mr. Pilgrim, this is just for my own purposes. In Barbados, that is considered a sufficiently specific address. Like in Trinidad, we have to say 9B or Light Pole 72. I noticed you just said something land. Is that considered in Barbados a sufficiently specific address? I'm just asking. I don't
Quite
know.
often houses in these small gaps don't have carry numbers.
Right. So that is sufficient.
There's no gap name either.
The gap is Dawson Land is the name of the gap.
The gap. Okay. Thank you. And the occupation, just because I know most forms carry an occupation.
She's a fish vendor.
Thank you.
Your Honors, if we could have her telephone number as well, please.
Yes. Thank you.
But Ms. Delaney, we're not going to put that in the order, right?
You will have
No,
it.
Your
You don't need to put the telephone number in the order. Thank you.
246 for Barbados, 236 9577.
246 236
9577.
9577. You got it, Ms. Delaney?
Yes.
Yes, thank you.
Anything else that you require from the surety, Mr. Laney?
No, Your Honor.
Yes. And anything else, Mr. Pilgrim, you require from the court in order to give effect to this?
Just the order, ma'am.
Okay. All right. So we will work hard in getting that order off today.
I'm obliged to the court.
Thank you very much. Okay. Anything else from my colleagues? Very well. Madam Deputy Registrar, you may close the proceedings.
Thank you, Madam Justice Rochnotley. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Nono. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. Do have a wonderful weekend. Be safe. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.
Thank you. Good day.